One.
Thank you. This is Tuesday, February 2nd, I think, and this is Senate Government Operations. I just am going to say a couple of the things that I say at the beginning of every meeting, that people who are in the meeting with us, we do not use the chat function except for Gail, who uses it to post links for us, but we don't use the chat function because I consider it a sidebar conversation, and we wouldn't allow that if we were in person in the meeting room. So, and I see Vince is with us here. It looks like accepting an award and looks so contemplative.
Where's that, Jeanette?
There's a picture of you up there, and you're standing at a podium, and there's a sign behind you that says VBSR.
Oh, right. That's right. That was obviously back a few years ago, but yeah, I never changed it, and I figured why not? You just leave it.
And now in this COVID world, Vince actually has a ponytail. So,
I doubt that. You won't see that.
Sorry. Okay. So committee, there was some confusion about what we were actually doing today, because I very late in the game switched Tuesday and Wednesday agendas. And so it got a little confusing here, but what we're going to do is we have S43, which is a bill that I believe that we did last year. And I believe Anthony reported it on the floor, and it was right. Am I right about that, Anthony?
You're right about that. I honestly don't remember if it passed the Senate or not.
I think that there were a bunch of questions that we couldn't answer, and so I think it was tabled.
Right.
Jeanette, last year, Jeanette, it was the California pension contract bill was S287, and it was voted out of your committee favorably on March 11. And then it went, I think, to a probes, or then things came to a standstill.
Well, it did get to the floor because Anthony reported it, and then because it was right, there were questions that we couldn't answer, so we decided to table it or let it lie, or whichever we do.
Okay.
And then COVID hit, so we didn't do anything more with it. Yeah.
But it came out of your committee with a nice favorable recommendation, which we were very pleased and thankful for.
Yep. So now, given S43, I believe, was probably introduced before we had the recommendations from the treasurer's office around the retirement issues, but they're kind of all tied together here. And so what I think we'll do is let Becky walk us through S43, and then we'll start a conversation about it. Okay. Does that make sense, committee?
Yes.
Okay, great. Okay, Becky, do you want to?
Sure. So Becky Wasserman, Legislative Counsel. So this is S43, which is an act relating to the contractual rights. Oh, I'm sorry. Should I be sharing my screen?
If people want to, or
I don't know if anyone else has a copy of the bill.
We have it on our website, and
Yeah, I have it.
Anthony?
I have it, so I don't need it shared.
I don't need it.
Okay. If anyone does need it, I can pull it up.
Okay.
For people listening, it's on the website under today's testimony under Becky's name.
Yeah. Rebecca's name.
Under Rebecca's name.
Rebecca officially. So it is an act relating to the contractual rights of members of the Vermont State Employees Retirement System. And the language itself, the bill is pretty short. It is adding a new section to Title III in the State Employees Retirement System chapter. So it's section 480C. And what the language is doing is saying that the provisions of the entire chapter for the retirement system creates a contractual relationship between a member of the state employees retirement system and the retirement system itself. And those contractual rights under this language are established after a member's initial contribution to the system. And then the last sentence of the language says that no amendments can be made that would diminish or impair a member's rights or benefits provided under this contractual relationship that's established under that section. And then section 2 of the bill is the effective date, and it is effective on July 1st of 2021.
Okay. Sounds pretty simple. I'm afraid it probably isn't as simple as it sounds. Thank you, Becky. Does anybody have questions for Becky? Brian, Senator Collimore, and then Senator Polina.
Thank you, Madam Chair. I'm not sure it's for Rebecca. I'm trying to remember what the problem was that this is trying to solve. That's all.
Go ahead.
So what this is getting at is that when there are changes made to a pension system, you're gonna do an analysis of whether there was a contractual relationship there that impairs whether that change impaired someone's contractual rights. And different states provide that sort of protection in different ways, in constitution, through statute, or court decisions. In Vermont, there's no constitutional provision that provides this, but there was a case in the courts. There have been a couple of cases that have dealt with a sort of issue of pension rights and whether it and how contractual rights are tied to those pension benefits. And there was a case, the Burlington firefighters case, that it wasn't really looking at the question in that case wasn't looking at changes to benefits, but the court did say that accrued benefits in a pension plan become part of an employment contract once an employee makes a contribution to the plan. In that case, it sort of indicates like how the court would analyze this question, and what they would do is look at it under a contracts clause analysis of, did a contract exist? Was there a substantial impairment to that contract? And if there is an impairment, if you try to change a benefit, then was it reasonable and necessary to serve an important public purpose? So, arguably this is, I guess, trying to codify what was in that case of saying that accrued benefits in a pension plan become part of the employment contract. I do think that it does sort of it changes that contracts clause analysis, however, because rather than looking at, is there a contract in place? This statute is actually saying, yes, there is a contract in place. So there wouldn't be that analysis of like, does this contract exist? And then it also could speak to that second prong of, was there a substantial impairment to that contract? Because the language of this bill says that no amendment can diminish or impair a member's rights or benefits under this contractual relationship. So I think you'd still use that same contracts clause analysis, but I think it changes how that would be done because it is creating an actual contract in statute. And so, I think the policy decisions here are, does this make it more difficult to make any changes to the pension plan, to pension benefits, if it is creating this statutory contractual right?
Thank you.
Senator Polina?
Well, that was actually a similar question that I was wondering about what other states do as well. And so without this happening, without this, a pension would not necessarily be seen as a contractual right then. It wouldn't be seen as a contract. Could you describe like what a pension would be seen as opposed to a contract? Because don't contracts get broken every once in a while anyway?
So, different states have different approaches to this. I think it was mentioned earlier that this was sort of based on this like California rule, because I believe that they do have this like statutory right to the pension benefits, but I think any change to pension benefits is really sort of fact specific on the system and what you are trying to change. So it's hard to say across the board whether or not, in Vermont system, what change would be considered a contract. I think this is, more, sort of blatantly saying like any rights under the system are a contract. So it does change, it changes
So
that analysis a little.
it strengthens those rights though, calling it a
Yeah,
contract.
this would be strengthening from that perspective. It is strengthening the rights of a member in the system to have contractual rights.
Which would make it more difficult to make changes.
Potentially, yes, it would make it more difficult to make changes.
Right.
And I think you had you had a second question, and I can't
No,
remember now.
that could be it.
Okay.
I was going to ask you about other states because I couldn't remember whether it's a common thing to do in other
I think
states.
it just varies depending on the state. I could do more research if you have like a specific state you'd want questions about, you have questions about, but I think they all have their sources of protections in different ways.
Let me just ask one other thing just to finish up. The Burlington firefighters case, does that came down in favor of this concept, but it's not enough to just rely on those cases. It's important to put it into statute if you support it.
So again, I think the case was looking at it was like a retroactive amendment to their pension system. It wasn't a change to a pension benefit. But what the court did in that case was say, this is how we would analyze this under this U.S. constitutional contracts clause analysis. And there's a lot of case law on how you would analyze that. And now I'm remembering your other question was, can contracts be broken? And the answer
Right.
to that is, that's sort of the third prong of that test is there are times where courts have found like, yes, it's okay to break this because it was reasonable and necessary to serve an important public purpose. And there have been occasions where pension benefits have been changed under that analysis. I think, so again, it's just specific to what you're trying to change and the reasons for why you're trying to change it. If there's a massive deficit and you've tried so many other options that this was the only thing you could do, that's the kind of thing that's been upheld by the courts of a reasonable and necessary purpose.
Reasonable and necessary, those are 2 words. Reasonable and necessary.
Yeah, those are the words that are
Right.
used in the case law.
Thanks.
Senator Clarkson, do you have a question?
Yeah, I'd just like to tag on to Anthony's question, Becky, if we could. It would be interesting to find out what states have done about this, and if states that have codified this, have any of them then subsequently changed the pension formula of contribution, or what happened. I think that, and because I don't know where that language is that it would be okay to change the contract to serve a greater public purpose that's reasonable and necessary. How do we set that bar? I mean, those are
So that's something that is, if this were challenged legally, that's like the analysis that a court would do of, was that change reasonable and necessary? I think the answer to your question is yes, this has happened in other states, and sometimes it's been upheld and sometimes it hasn't. So it depends on what exactly you're trying to change and the specifics of that situation. So if you have an example of something that we can talk more specifically about what kind of research you want to have provided to look at what's been done in other states.
So I believe that this was, I'm not sure who introduced this, but I believe it was probably at the behest of VSEA. And it just affects state retirees, right? Not teachers.
This bill is specific to the state employees retirement system.
Okay. So I think that we'll go to Vince. Are you done with
Oh,
your?
Keisha has.
Oh,
Keisha has a question.
I'm sorry, Senator Ram.
I'm sorry, it's just hopefully a clarifying question before we hear from labor
Yeah.
folks, or maybe they're in a better position to answer it, but does this mean that something gets bargained with the state administration and then becomes codified in statute, and then it's the contract, right? Because the contract's usually bargained with the state, so we don't become in a position to join in any bargaining. It's whatever is decided then becomes what's in statute.
So I think the answer to that question is that this isn't impacting, trying to impact collective bargaining rights. There's a section of law, I'm not remembering, Damien would know, in Title III that says that anything that is not restricted by statute is bargainable. So if
Okay.
so this is just saying, so you can still have those bargaining agreements on things that are not covered in statute, if that answers your question.
So this covers elements of the contract that exist in statute, but not.
It's not covering elements of it's saying that there is a contractual right to whatever benefits are provided in statute.
Okay.
All right. So are we ready to hear from VSEA about where they are? And then I think we'll hear from VSEA and then Mike O'Neill from VTA and then Tom Waldman. Does that work? Okay. Vince, are you ready?
Yes, I am. Good morning, and thanks for taking up this bill that's important to our 6,000 plus members. I am certainly not an expert on retirement, but to respond to Senator Ram's last question, retirement is not negotiated at this time. Other, collective bargaining issues such as pay and benefits and labor related issues are negotiated between the VSCA and the executive branch, generally every 2 years, with of course side letters and modifications as the need arises. But retirement is not negotiated. If the lay version of this is that if this legislation is enacted into law, there will be a protection for the employees that would be that have already vested in the system. So it takes away the analysis that the court would otherwise be required to undertake if there was an attempt to take away or reduce a retirement benefit. So it would be as a matter of contract, and then the question would be, was there any basis to modify or break the contract on the part of the state or the VSEA representing its members. And it's known as the California model or the California rule because California was the first state to, as I understand it, move forward with this protection for state employees with regard to their retirement benefit. So to restate it just one more way, once you vest in the retirement system, the executive branch, as well as the General Assembly, would be precluded from taking away the benefit in effect when you vested in the system. At least that's my understanding. So it gives some level of protection to the workers who oftentimes will take on employment with the state of Vermont and forego generally higher compensation because they know that as part of the compensation package, they will have a retirement benefit and this is what it's going to be. And then, halfway or a quarter or 3 ways through your career, someone can't come along and say, well, we've decided that we think that benefit should be adjusted or modified. And some employees would, of course, fall on the short end of the stick with regard to that discussion. So that's the thumbnail sketch of my understanding of the rationale behind the bill to give additional security to our state workforce once they have vested in the retirement plan with regard to their retirement benefits.
So I'm going to ask the committee if they have any questions for you, but I'm going to jump ahead here a little bit and ask if what this means is, for example, there has been right now some suggestions by the treasurer that the COLA be either eliminated or reduced for going forward. Are you saying that if this were law, that would not be able to be affected for those people who are currently vested in the system?
That's correct. It could apply to prospective employees, but the individual who has vested would have those rights secured essentially by contractual agreement. And so if you wanted to modify them, you'd have to make some type of, as you would in any negotiation, there would have to be some consideration in exchange for giving up something. That's generally the way a contract modification takes place. What are you offering and what do I get in return? And that discussion would take place.
So the same thing would be true for increasing the employee contributions or any of the suggestions that have currently been made. And remind me, when is somebody vested? Becky, it's as soon as they start paying into the system?
Yeah, so this language creates this contractual relationship upon a member's initial contribution to the system.
So as soon as they start paying in. And remind me, Vince, when do they start paying in?
I think it's 6 months. I think you're I think the benefits of the classified system kick in at 6 months. Now that's a guess, but I believe it probably applies across the board.
Tom may know too when we get to him. So Senator Polina.
This is basically for Becky, I think. My assumption is, or my thought is that this doesn't necessarily mean those changes could never take place, but it strengthens the worker's position in terms of making sure that it's seen as a contractual right as opposed to not a contractual right. So it doesn't mean that the benefits couldn't be changed, but it would sort of strengthen the position of the worker in terms of making their case. Would that be a fair way to put it?
From my position, yes, it gives you that level of protection, so it would not be unilateral. It would be a
Right.
give and take.
Becky, do you see it that way? Was I not clear in my question?
Yeah, no, I think your question was clear. Yeah, I think like if you think of it in terms of this, looking at a challenge to any change to your benefits as this sort of three-pronged test of, whether there's a contract, whether what you changed was considered substantial impairment. And then the third part, I think, is answering your question of, well, even if it is, then there are times in which a state can do that if it's reasonable and necessary to serve this public purpose. And that analysis, so there have been times that it's been found that it was reasonable and necessary. Usually if there's sort of significant financial distress on the part of the state and they tried other sort of less drastic measures to address that fiscal distress and there was nothing else that could be done. So it doesn't say that it's impossible. I think it is sort of attempting to answer maybe that first and possibly the second prong of this test, where sometimes a court can look at these sorts of questions and say, there wasn't even a contract here, so we're not even going to get to that other part because there wasn't we haven't found that a contract existed between members in the system and the system.
And the
And
reasonable, I'm sorry. Well, the
go
reasonable and necessary phrase, that comes under, that becomes viable because it's a contract. That's where the reasonable and necessary comes into play.
Yeah, I mean, that's those were the sort of the words used in a certain Supreme Court case that has now been sort of analyzed in a number of different situations of what constitutes reasonable and necessary. So, but yes, you only get to that third part of the test if you've found that there was a contract that was substantially impaired, and then you say, well, was it okay to impair it under these specific circumstances?
Thanks.
So let me, in this case, there are these three prongs, and in this case, if this passes, the first one is answered already. They don't need to determine whether there was a contract because we're saying there was a contract if this
Correct.
passes.
Yeah,
And
I
then
think
the second one is the substantial impairment. And does that mean that it's a substantial change? So if we change something from $5 to $4.98, that might not be substantial. But if we change it from $5 to $2, that might be. Is that what that means, substantial impairment?
yeah, I think there would be, there's been different interpretations of what constitutes substantial. I think where this language comes into play is that it does say you can't diminish or impair any of these rights. So, you know, I can't really guess how that would play into this analysis, but I think it does add, it perhaps changes how that analysis would be looked at of whether it's substantial. And I did just want to add that in terms of COLA and, for example, medical benefits, I don't know. I mean, I know sort of OPEB medical benefits are not considered part of the retirement system. I think from things I've read, COLA has also been treated differently as from a pension benefit. I mean, it is based on your pension benefit, but it is not. I guess I wouldn't. I don't necessarily agree that it would be part of this
Okay.
language here.
Okay. Thank you. Mike?
Good afternoon.
Hi.
I think Vince explained, at least from a union perspective, all of that very well. I agree with his assessment of this, that it will just provide some protection for state employees, that if we are looking at potential changes being made to the system, there is going to be a guarantee of a fair process. It will be understood that there is a contract with employees, and if changes are going to be made, it needs to be done in consideration of that contract. And if we're going to diminish a benefit, they may have to enhance another benefit somewhere else so that we follow this standard. So the VTA does support this. I don't know that my understanding of it goes a lot deeper than that, to be very honest. There were a few questions that I heard is, do employees immediately start paying when they're hired? I believe the answer to that is yes. They start contributing to the retirement system when they are hired. And vesting occurs at 5 years. For all state employees, I believe they're vested in the system when they have 5 years of service. But they do start to pay into the system and contribute upon being hired.
Thank you. Any questions for Mike? And I have to say, this committee is totally blessed right now. We have two Vince Aluzis with us.
Oh, boy.
I know.
Watch it. Watch out.
Yep.
So-
Yes, Senator Clarkson.
May I just clarify? So I one person said we're vested after 6 months, and Mike just said after 5 years. So which is it?
I believe it is 5. Well, my understanding is 5 years. I was a state employee. I retired. All of our members are vested at 5 years in the system, and they do start contributing into the system upon being hired.
I think that the question for what might be one for Becky, is it when they're vested or when they start contributing?
So that's right. Thank you, Jeanette. So the difference, what
Right.
Becky may have said was they start contributing at 6 months. but they're
I,
vested at 5 years.
yeah, I
But the-
actually, I don't know the answer of when they start contributing, but the language of the bill creates this contractual relationship upon the first contribution to the system. It's not upon when you vest in the system.
Okay,
I think the thought with 6 months, so where that came from, maybe state employees are on probation for the first 6 months of employment, but they are contributing into the retirement system during that time. At 6 months, they complete their original probation.
so this bill would go into effect the minute they make that first contribution. That's what Becky just said. Right, yeah. Whether they're vested or not, or whether they even get past 2 years of employment or their probationary period. But anyway. So any more questions for Tom? Right, I mean, for Mike right now? Okay, so Tom, do you want to
Oh,
talk to Senator
Matt.
Clarkson?
Thank you. So Mike, in your time in this capacity, I guess this goes to Mike and Vince, there have been changes to the pension system, right? I mean, we made a fairly major change in what, 2007, 8?
Yes. At that time, we increased the contribution rate, and it was an agreement between the unions and the treasurer's office at the time.
Right.
In the legislature, obviously.
And yet, was this not thought about being asked for at that point?
I don't believe the bill was asked for. There was a lot of discussion at that time about the issue of a contract. And we looked at what had gone on around the country and some of the rulings on these issues around the country. VSEA and the VTA at the time had a legal opinion given to us by an attorney that gave this same opinion, that they believe there is a contract, but at the time there was nothing in statute in Vermont.
Could I give an analogy, Madam Chair?
Yes, please.
There are a number of employment law cases in Vermont, and as many of you know, most workers in Vermont are not unionized. So the analysis the courts often will start to take at a non-union workplace is they look at the employee handbook, and they look at the employee handbook to determine whether there is an implied contract, whether there is an agreement created by the words of the employee handbook that can be interpreted as a contract. And then if the answer is yes, then they go to try to enforce it. But it requires a case-by-case analysis. And as has been suggested here this afternoon, what this bill does is it says to the court, you don't have to worry about doing that analysis as to whether there's a contract here. Our position is that there is a contract, and then therefore we don't have to argue back and forth. Now, I was in the legislature in 2007, so I wasn't privy to the discussions between the unions, but an opinion of an attorney, as you know, is subject to disagreement or even change by that very attorney. So once it's in statute, you have something that you can sink your teeth into and then move forward with that basic premise already established. So if that helps to explain it, that's what I offer.
Okay, Tom, would you like to join us and weigh in?
Certainly. I'm Tom Waldman. I'm the General Counsel for the Department of Human Resources. Madam Chairwoman, I expected that someone from the Treasurer's Office would be here. And
well, I think that there was some confusion because what I said at the beginning about switching conversations, and so that unfortunately got lost in the translation.
I would suggest that it's really important to hear from the Treasurer's Office, since the retirement system is their baby, and it's not the baby of the Department of Human Resources. From my perspective, there is a Supreme Court opinion from the Vermont Supreme Court that basically holds that members in a retirement system have a contractual right. To the extent that this bill does nothing more than codify the existing case law, DHR is fine with it, but I think it's really important that the committee get input from the treasurer's office.
Mhm.
You know, my marching orders were to defer to the treasurer's office. And they're not here. And I think it's really important to hear from the treasurer's office on this bill, because it really will, if it's passed, it will impact the treasurer's office more than it will the executive branch or the Department of Human Resources.
Right, yeah. Yeah. Senator Polina?
Just to be clear, the case you're talking about, it's from the Supreme Court, that's the firefighters case?
Yes.
Because other people have mentioned to me, they've said, well, we already do this in practice. This would be codifying it, but you know, some people might say, well, there's no need to pass this bill because this is the practice that we operate under anyway. Does that make sense, Rebecca? Or to Tom, either one of you?
Well, I would say this. I mean, you know, to the extent that the highest court, the court of last resort of the state of Vermont, has addressed this question, as it stands right now, that is the law in the state of Vermont. Members, public employees who are members of a retirement system have a contractual relationship with that retirement system. Codifying it would provide additional protection insofar as a court can always reverse itself.
Right.
Whereas if it's codified, then it's written into statute, and the court would not be able to, the court could interpret the statute, but the court would have no say on the question of whether or not a contractual relationship exists.
Thanks.
Okay. Anything else? I apologize. My fault entirely that we didn't get the treasurer here, and that we and I guess my question in going forward is for the committee, do we want to combine this conversation with the conversation with the treasurers, with the treasurer and others who want to testify on the potential changes that have been proposed? Is that a conversation that we can have kind of all together and then separate them at the end to see where we want to go? Committee, what do you think? What are you thinking about that?
I'm honestly not sure. I hadn't thought about it that way. I'm really not sure at this moment.
Okay. Senator Collimore?
Thank you, Madam Chair. I agree with Senator Polina. I don't mind having a discussion about both topics, but in terms of kind of putting them all together in a single bill or?
No.
Yeah, okay.
Yeah, I wasn't thinking of putting them in the bill, but are they so closely related that we want to talk about them kind of in the same conversation and then determine what, because we're going to have to determine what to do with this bill, and then we're going to have to determine what to do with the potential changes. So that would be kind of separate, but is it worth having the conversation kind of together or not? Senator Clarkson?
Yeah, they're part and parcel. I mean, they go hand in glove. So it strikes me that we have the conversation together. They're the same witnesses. They're the same, you know, if we're trying to make good use of people's time, that the same voices are weighing in, I believe. So it makes sense to do them together.
Okay, why don't we then schedule next Tuesday afternoon? I think that what we're going to do on Tuesday is tackle the executive order around the Agency of Public Safety again, and then look at this question and get all the right people in the room. Does that make sense?
Yes,
Anthony.
And I think I appreciate Senator Clarkson's analogies, you know, hand in glove, part and parcel. That swayed me quite a bit, I must say.
Oh, don't unleash me.
No, don't. So I am reminded of this morning when we had our, and it was a slightly different meaning, but I loved the devotional when she talked about when we try to do things in black and white or right and wrong and whatever, and that has a seductive simplicity. And I don't want to make this seem too simple, but all right, so we'll do that then. Does anybody else want to weigh in on this again right now today? Or should we leave it till next Tuesday and we'll get the
Madam Chair, the only comment I'd add is that Treasurer Pierce is an embodiment of what this bill would require in future decades and in future years when retirement is debated. She has been very open and transparent and has sought our suggestions and our input. And that we believe is the model way of moving forward with changes to retirement. As the law sits today, as it applied to the Burlington case, we would have to make the argument that there is an implied contract and that we should be consulted before any changes are made. So what we're trying to do is codify the approach that has been taken by Treasurer Pierce with a dynamic, all-encompassing discussion about how to move forward. And that's what we're trying to codify by way of this legislation. We may not always have Treasurer Pierce as our state treasurer, and this will essentially codify her approach to these very important issues to our members.
all right.
Uh,
Okay,
May I ask a
Yes.
question, Madam Chair?
yes.
I apologize. I don't know the date. What was the date of the Burlington firefighter case?
I believe it was from 1988.
Oh, it's a long time ago.
Yeah,
I mean,
Senator
Yeah,
Rahm.
it's an
Oh.
older case. Yeah, 1988.
thank you.
Just a question about what's customary when hearing witnesses. With both of these issues, will it make sense at some point to hear from retired state employees or people who serve on the retirement board? I don't know if it's most customary for Treasurer Pierce to always speak for, the retirement board, or if it makes sense to hear from people who are affected on these issues.
Well, there's two different groups there, people who are affected and the retirement board. And I don't know if the retirement boards themselves, they have sent written testimony to us. And I don't know if they want to weigh in, or if they have given their written testimony and then trust the treasurer to get their message across. But we definitely will hear from people who are affected.
Okay.
And we will have to limit that because we have about 15,000 people who are affected by any changes that are made. And we clearly can't hear from 15,000 people, although I think I have, and
Yeah.
you probably have too. But so we'll hear from some people and we certainly want to hear like from VSEA and NEA and the VTA and their retirement people or their presidents, and let them have some people come in and testify. Senator Clarkson?
Yes, I'm just curious. I mean, this deals just with the state employees, this
Mhm.
bill. Does it make any sense to include teachers as well if we're codifying something that's been established already I'm just curious why they're not included. And I would say that, Mike and Vince represent large and in many ways, Tom represent large swaths of that 15,000 person population. So we have representatives of those affected of those affected persons. But it strikes me, it's already a patchwork I mean, two major pensions, I guess that's not a patchwork, but that's, does it make any sense to codify it for both at the same time, and why we're doing it for one and not the other? Or are the teachers already codified? I don't think they are they?
Well, let's, I mean, Jeff Fannin will certainly be included in any conversations going forward.
But
I don't want to.
But teachers aren't.
No, but I don't think
They're not,
that- I
there's
think we
not a
need to-
similar provision, no.
Right, and so we need to hear from NEA first before we even consider whether maybe they don't want to be in here.
Well,
maybe,
but right.
We'll hear. Yeah, we'll definitely hear from them. I mean, he's on the list for anything. I mean, and then there's the municipal employees, and
yeah,
that's a whole nother one, and I don't think we want to go there.
But where is their pension in this pantheon of pensions?
It's with the treasurer's office.
Right, I know it is, but it's not included in these discussions at the moment in terms of our pension liability, is it? I mean, under what umbrella is it? It's
the treasurer is not proposing changes. My understanding, changes to the municipal retirement system, because the municipal retirement system is fiscally sound.
Right. That's my understanding as well. So it's in reasonably good shape. So
yeah.
But you're right. If we're going to codify, why not do the whole kit and caboodle?
Well, let's find out if they want to and what the advantages and disadvantages are.
Exactly. But
yeah. Anything else? I apologize for not getting the right people here, but we will next time. Okay. Thank you, Becky.
Thanks, Becky.
So we wanted to have a conversation about about temporary workers, and I know we don't have a bill, but Vince, are you prepared to talk to us about temporary workers? And this does affect the Department of Human Resources, I believe. And so we have and Damien is with us now, and Dan is with us, and so let's start with Vince, of what you see as the issue with temporary workers.
Okay, great. Well, thanks again. Last year, your committee, at least the House committee, I take it, took this up in the context of H334. It was titled, "The bill proposes to clarify requirements related to the use of temporary state employees and to permit long-term temporary state employees to collectively bargain." And so if memory serves correctly, this bill was first acted on by House Government Operations Committee, and then I believe it was referred to the House Appropriations Committee. And like the bill we just talked about, when COVID struck and the State House essentially reduced the scope of its work to the more essential legislation that was needed to pass, this bill died on the vine and of course expired when the General Assembly adjourned for the year. My recollection of the testimony from last year is that we have had state employees designated as temporary employees. And when you read their retirement announcement or their obituary, it'll say John Doe or Jane Doe worked as a temporary worker for the judiciary for 22 years. And temporary workers do not enjoy the benefits of the classified system as do classified employees. And so the gist of this bill is to state that after you have worked for the state a certain number of hours in 2 successive years, you then become converted to a a classified state employee. It's akin to working side by side with uh, a fellow worker, where one receives the benefits and protections of a classified workforce, and the person sitting next to you was hired at a point in time or based on budgetary considerations as a temporary employee, and they simply leave them as temporary employees uh, in some cases for decades. So we're trying to address that inequity and allow all folks who really have worked as a temporary employee, and for reasons determined by the managers, the management, that they have been there for 2 years, they've worked more than the minimum required number of hours. I don't have it committed to memory, but either 1280 or 1240 hours comes to mind. If you've done that for 2 successive years, then as a matter of law, you would be converted to a classified employee. That's the thumbnail sketch of the bill. I'm trying to bring it up. In, I don't know if you folks have it in front of you, but
No, because we don't have a bill yet, so.
well, we've asked that it be introduced, and I don't know, Tom was working on getting that bill introduced. So I can't tell you what the status is or whether it's in the hopper at Ledge Council at this time, but it's something which has been an issue dating back, to when I was in the legislature in the 80s and 90s and 2000s. The word abuse sounds harsh, but if you're a temporary employee and you've been a temporary employee in some cases for decades, it's a bit unfair to that person because they don't enjoy all the benefits that a classified state employee does. And as we've discussed in other legislation in other contexts, um, uh, oftentimes individuals will work for the state because they know they're not going to become millionaires, but they do know that they will be taken care of in retirement with regard to a pension and perhaps with regard to health care. So that's the trade-off. They know they're going to have a steady course in life during their work years, and then when they retire, they won't have to worry about where their next meal or how they're going to pay the electric bill. You try to provide for them on both the healthcare front as well as the retirement front. So we're trying to make it even, Stephen, for a person who has successfully worked as a temp, convert them to a classified, and then allow them to work side by side on the same terms and conditions as their colleagues. I think that's the thumbnail sketch of the bill.
So just 1 second, Senator Clarkson. You said that it did 2 things. It clarified, we need to clarify what a temporary employee is and when they become non-temporary. And you also mentioned collective bargaining, but temporary employees should not be there long enough to have to bargain. They're either temporary or they're in the classified system. So I don't know that reference.
Temps do not bargain. They
shouldn't bargain.
Right. They don't.
Right. And they shouldn't be there long enough to have to bargain.
Right.
That's my point, is that.
Right. And as we all know, they are. It's 12. I'm looking at H334 from last year. It's 1,280 hours of work in any one calendar year.
In any one?
Well, it's 1 year. You have to work 1,280 for 2 years in a row. So you've worked 1,280 1 year, and then you work at least 1,280 the next year. Then you are converted to the classified state system.
Okay, so
under the bill was introduced last year, it also provides some additional benefits while you are a temp, sick and annual leave. We had testimony last year where people will go into work because they don't have sick leave. And obviously, as heightened by the COVID-19 discussion, you really don't want someone who has the flu or other ailment that's contagious to be compelled to come to work because they need to make ends meet at the end of the week. So, and it creates good cause. You can't terminate them unless there is good cause. Obviously, you wouldn't terminate them unless there was good cause. And after 6 months, they get health insurance benefits that satisfy the minimum essential coverage contained in the Affordable Care Act for individual persons. So that's another highlight of the bill.
I don't want to go too deep into the bill
Okay.
itself because we don't have it yet. So it's hard for us to have a discussion on the merits of, and we don't know what will end up being in the bill this year.
Okay.
So as Senator Clarkson, did you have a?
Yeah, thank you, Vince. I had pulled it up from the House General's webpage from last year, so it's easy to find if people want to look at it. I guess I'd like to know how big the universe is that we're talking about. How many people currently are considered temps, and how big a problem is this? I know it's a problem. The question is, how big is it? How many people are we talking about?
I would respectfully defer to HR because they have the statistics. We don't have those stats to my knowledge. Maybe Steve Howard has them, but since we don't represent temps, we don't have those stats. So I can't answer that question right now.
I'm sure HR has it somewhere in there because they do every year this great workforce report. And it's always in there. Of course, we're not there right now, so I don't know what the workforce report looks like. But any other questions for Vince at this point about the concept? And I guess what we also need to do is look at the difference between permanent part-time. I mean, you can be permanently part-time, but you're a permanent employee. You don't have to be full-time just to be permanent. And there's also then I don't know what it's called, but special projects, limited something or other is the term. And I don't remember what that term is, but that's different than a temporary employee. So we need to figure out how to distinguish those people who might be hired to work part-time or even full-time on a project that is of limited duration. And so they're there for a period of time. That's how I operate in my other job. That's who I am, whatever that term is. So anyway, so let's move to HR. How do you want to do this? HR people here, I think, is Tom still with us? I don't see him. I see Dan and Amy.
Right. Madam Chair, I think that's, Tom was not scheduled to appear at this hearing.
Yeah, okay.
So I'll be presenting the two temporary worker reports that we are required by statute to provide each year. And I think you have them up. If I saw Gail's message correctly, they are up on your website now.
Okay. I only have one. I can't look at them right now. You'll have to talk me through them because I only have one iPad here with me today. So I either look at you or the report.
Well, given the condition of my face right now, because I'm undergoing some treatments, you might be better off looking at the report.
It's fine. So if you would just kind of answer, I guess, Senator Clarkson's question and where we go from here and what the thought is and how you would differentiate those people who work on limited projects and the idea of becoming permanent after where you stand on this.
Okay. So first, thank you for allowing me to testify here today. Appreciate that. For the record, my name is Dan Pouliot. I'm the Deputy Commissioner of Human Resources, have been since June of 2017. And I will confess, I had some connectivity issues towards the end of Mr. Luzzi's presentation, and I didn't get the question from Senator Clarkson. I apologize.
Her question was how many? What's the universe of people we're talking about here? Is it 5 people or 250?
Oh, okay, great. So what I'd like to do then is kind of go through the report a little bit and a little bit of the history here, and then but I will certainly answer those questions. First off, the reports that we're giving you are the 2 that are required by statute. The first concerns executive branch temporary employees who are non-seasonal. And the second one concerns specifically seasonal temporary employees. And the reason we split them out is due to the legislative change that was made in the 2018 session. I think it was 2018 session, maybe 2019 session, that asked us to split them out and treat them a little bit differently. And these are calendar year reports. So I'll give you the highlights of the 2020 report. And that is that we had actually a few less temporary employees in 2020 than we have had in prior years. They totaled 841 non-seasonal employees in 2020. Of that number, of that 841, we had 31 temporary employees who went over 1,280 hours last year, right? So that's 3.7% of that population. 20 of those were specifically related to COVID response requirements to go over the 1,280 hours. And just the highlights, the Veterans Home down in Bennington had 8 of them due to obvious concerns down there. There are a lot of their regular staff were out for extended periods of time, et cetera, et cetera. So the temps that they normally have down there, several of them went over 1,280. They don't usually. The Department of Public Safety had 5 people that went over 1,280. A few of those are in the E911 PSAPs. Those we have talked about for at least the last 2 years during this testimony. And 2 of them were people who normally work a limited number of hours in Vermont Emergency Management. But of course, because of this year's 2020's unusual events, the SEOC has been activated since February, almost consistently every week since February through the end of the year. So 2 of those people who normally work just a few hours went over 1,280. The rest of the 31 are 1 or 2 per department for various reasons. A more important statistic, I think, that gets to Senator Clarkson's question, if I understand it, is that of those 31 people that went over 1,280 hours in 2020, only 3 of them worked over 1,280 hours the prior year, 2019. 2 of them we've talked about at testimony in the last couple of years. They work in the PSAPs, the 911 centers. I think one is in Williston, the other is in Westminster. These individuals are retired state employees. There are always classified openings in the PSAPs because they are chronically understaffed. They have a lot of turnover. It's a high stress job. There is a requirement in that job for mandatory overtime. That mandatory overtime requirement doesn't apply to temporary employees. So these folks who are retirees of the state have their full pension and OPEB benefits from the state, continue to work as temporary employees because that's their choice, right? It gives them a little bit of flexibility in being able to turn down overtime when the classified employees are required to do so. So, as opposed to being disadvantaged by being in their temporary status, these 2 folks out of the 3 are actually advantaged to some degree by being in the temporary position. The third that worked over 1,280 in both 2019 and 2020 is a retired medical private practice person who works for Dale. Disabilities, age, wish I could say that. It's Dale. In any event, he normally, he has worked over 1,280 for the past few years. He is a gentleman who has his own retirement. He prefers to be in the temporary role. and we haven't asked them to do otherwise. So in the executive branch, right, again, I want to highlight a couple of things. 3.7% of the temporaries worked over 1280 last year, and only 3 people out of the 841 worked over 1280 2 years in a row, or 2 or more years in a row. None of them are looking for benefits to be paid by the state. So that's kind of the highlights of the non-seasonal, the regular temporary employees. And I do want to just highlight one other set of statistics, and that is since 2017, when the current administration started managing temporary employees, we've taken a very strict view with regard to the law, the statute that governs temporary employees. We have reminded appointing authorities across the state and departments and agencies of the statutory requirement to limit temporary employees to the statutory limit. And I will tell you, in 2017, there were 75 people. In fact, I'm going back to 2016. Before I got here, there were over 100 employees that went over 1280 that year. In 2017, when we started managing it, that number dropped to 75. In 2018, the number dropped to 46. And in 2019, that number dropped to 32. This past year, 31. And again, that would have been significantly lower had it not been for the impact of COVID. So I think that the process that the executive branch has taken to be in compliance with 3 VSA 331 have really paid dividends and been honest and open about it. So I needed to get that out. The second piece of the reports that we provide it concerns seasonal employees. Again, there were somewhat fewer of them in 2020 than there were in prior years. This past calendar year, 2020, there were 522 seasonal employees. Parks, Fish and Wildlife, who normally are heavy users of the temporary positions for seasonals in the summer.
I have were you continuing? I heard a big pause there. I wasn't sure if.
I'm sorry. Yes, I am continuing.
Oh, okay.
May I ask just a question before, Dan, you continue too far?
Sure, Senator.
Just to quickly go back to the non-seasonal temps and your very decided drop every year since 2016 in the number of temporary employees. Was that an intentional management decision on HR's part to limit? What do you owe the drop in seasonal in non-seasonal temporary employees?
Okay, I want to make sure I say this clearly. The drop that I cited from 75 to 46 to 32 to 31, that's the number of temporary employees that exceeded the statutory limit of 1,280 hours.
Right.
And that is certainly an intentional effort on the part of HR and the administration to be in compliance with the statute, 3 VSA 331.
Good.
Right? We were taken to task, and quite correctly, I think, several years ago about being fairly lax in the management of that statute. I think we've done a great job with it.
Great.
So on the seasonal side, again, there were 522 seasonals employed in 2020. 10 of those went over the new statutory limit of 7 consecutive months of employment. And I signed waivers for 5 of those based on specific characteristics of the jobs they were doing. In 1 or 2 cases, there were changes in the type of work the individual was doing, which took them beyond one season into another. And then of the 5 people the 5 individuals who went over that 7-month limit without a waiver, All 5 of those worked less than 7.5 months. So it was basically 7 months and a week or 7 months and 2 weeks. So total of 10 went over 7. That's 1.9% of the total employees employed by the executive branch last year. I think we did a pretty good job with that as well. I'm happy to take any questions on the subject.
I have a question here. And how do we, I know that 1280 is the magic number for considering them non-temporary, but if there were 841, that leaves 810 who were temporary employees who didn't go over the 1280. They may have been at 1,000, but they were still temporary. And I wonder when we think about making temporary employees who don't go over that so that they become classified, but think of them in terms of kind of permanent. They might be working 5 years or 10 years at 1,000 hours a year, so they haven't met that threshold yet. But have we thought about ever? I know that I worked 8 years part-time. I wasn't considered temporary, but I had prorated benefits. And I know a lot of employees start their benefits, their prorated benefits at 20 hours a week, which is 1040 a year. And have we thought about extending benefits, prorated benefits, to those people who are under the cap, but who continue to work in a job part-time temporary? Did that make any sense?
I think
Yes.
I get the gist of the question, yes. So I can't honestly say that we've done any in-depth analysis on what that would mean to the cost for the state, but we can certainly do that, Madam Chair, and I can try to get that back to you in fairly short order. And I guess what I would do there is take those numbers of employees who exceed an average of 20 hours per week and try to estimate what their benefits might cost if we were to engage in that change.
Yeah, and they clearly would have to be prorated. I mean, if you were working, I worked 3 days a week for 8 years, and I got 3/5 of the benefits, and I paid. So I paid for my health insurance 2/5, and my employer paid 3/5. I got 3/5 of the vacation time and 3/5 of the holidays and stuff. So it isn't full benefits. I just wondered if we'd thought about that.
Madam Chair, we've proposed that in our legislation in the part that provides some benefits to those who work in a temporary capacity. We didn't use the word prorated, but it is a truncated benefit package for temps.
So to follow up on that, I would like to see how this other 810 break down here. Because there were only 31 who met that threshold, but of the 810 that are left under the non-seasonal, how do they break down? Are they working 1,000 hours a year for 10 years, or are they truly temporary people that are there for only a limited amount of time? Or are they like me, who was part-time for many years? And do we consider them temporary?
Right. So I'm sure that when we go back and run the data on those folks, we'll find a wide variety.
Mm-hmm.
But I'd be happy to try to parse that out into some reasonable segments so that we can give you a clearer snapshot of where they fall of those people that are below that 1,280 threshold.
Thank you.
So, and that's why the Director of Classification and Position Management, Amy Pope, is here with us today, so she can hear these questions directly.
Good. I see that. Senator Clarkson?
So I'm just curious, Dan, you did great work on the 3 in terms of identifying why they had chosen to continue to be temporary employees, and it clearly suits them and they've made that choice. They're already retired, so they're already benefiting from one of the benefits of having been a full-time person. So they're slightly different kind of case. Did you do any analysis on all these other people that worked in a temporary capacity and what their reasons were for working in those capacities?
I'm not going to say I did an in-depth analysis on each of them, Senator, but of the 28 that aren't the 3 we just talked about, 20 of those, actually 19, I should say, 19 of those worked in excess of 1280 this past year, primarily related to their role in COVID response.
Yeah, and I think you said 2 worked in the Emergency Operations Center. So.
Right, but so you haven't done, there wasn't a questionnaire done for the temporary employees to
I think I've lost you.
Are you there with us, Dan? Did we lose Dan or did you lose me?
No, I can hear you.
Yeah, you're still with us. Dan's frozen.
Okay. So, Amy, maybe you can, I don't know. I mean, Dan did talk about the, like 5 were in the PSAPs and 2 were in the EOC and 20 were, because of COVID, they worked overtime. I mean, over that number of hours. Can you just help me understand when we think of somebody as a temporary part-time or a permanent part-time? Do we treat them as, and I think I asked this for Dan, and then how do we distinguish between this, whatever this term is, limited something and
Limited
temporary?
service?
Are you there, Amy? You are muted. There you go.
Sorry about that.
So how do we distinguish between, or where do we draw the line between limited something and temporary?
So I'm Amy Pope, Director of Classification and Position Management. And I don't know if Dan, I think Dan's frozen still.
I think so, yeah.
So he's free to interrupt at any time as I'm talking with you. Limited service positions are, yeah, so those are, you can go to 32 BSA 5, and that is where limited service positions are authorized and how they're authorized. And they typically are authorized associated with a specific grant. So you were talking about a specific project, right? So once the idea is the position would end when that project ends. So a grant, for example, the VDH received a grant to help with their response. They received 14 limited service positions, and ultimately the funding will be appropriated, and the funding is used through those positions. And then once the pandemic is over and the need for those positions and the funding would go away, and the positions go away. Part-time temporary, those positions we only authorize if it's 20 hours or less. And we're very careful on when we give those temporary positions to a department. We usually look at a temporary for a fill-in need. An employee may be out on leave and the need to continue the work may be necessary. So we would identify a temp as a fill-in for a very short period of time.
Do we have a part-time permanent category?
We do, yes.
Okay. But these 800 people fit into that category that you just talked about, where they're filling in for somebody, or there's a immediate need for somebody, or.
There's a wide variety. We have a few temp types. It may be sporadic. It may be an emergency need for 6 months. We have contact tracers, for example, or temporaries, and those are considered a bona fide emergency. We have intermittent. It may fluctuate in a workload, or I said sporadic, and then again, the part-time ongoing. So those are all the specific temporary temp types we use. And then we do have a part-time classified, limited service classified. Those are still classified employees.
Any questions for Amy or Dan? Oh, I saw Dan move his head, so he's unfrozen. So any questions, committee, that Senator Clarkson?
You may have clarified this and I just missed it. I'm battling a headache today. The part-time, full-time, or the part-time classifieds, I mean, is that the same thing? Do they get, as our chair discussed, do they get prorated benefits? If they're in a full-time capacity, but they're part-time, do they get benefits of some variety?
A part-time classified
They can't be
employees.
full-time, part-time. They're either
Right,
part-time
but
or
we
they're full-time.
talked about part-time who were temporarily employed, but then we also, I thought, talked about part-timers who were full-time part-timers, or part-time classified.
Part-time permanent. You can't be
Right,
part-time
part-time
and
permanent,
full-time.
right.
Yeah.
Do they get prorated benefits?
Didn't know, Dan, if you wanted to take that, but
No, I don't, Amy. I think that's for you.
they do get a prorated. I don't know the specifics of that. If you needed that information, I'd have to research that specifically for you. Some work like a 32-hour-a-week schedule. Some may work 20 hours a week. So then I think it's prorated by the hour, but I would have to get back to you on that.
Senator Rahm?
A lot of the positions at the Veterans Home, sorry about my dog, are utility workers. Is that a healthcare position, or is that like a maintenance position? I wasn't.
That's a great question. And it's one I had myself when I first saw the term, because I assumed they were all kind of like plumbers or working out in the yard. But what they do, they actually are, it's a variety of things. They're not medical workers, but they provide personal care. They're buddies. They perform services for the residents at the Veterans Home that are not specifically medical related.
And
so utility,
yeah.
I'm
no,
sorry.
I'm
so utility work, it's more like a utility infielder.
Yeah. And they're considered, I mean, I think they sound critical, you know, to their well-being. Have a lot of those other workers been taken out of the, okay, I'm not the only one with a pet.
No, Vince, I won't comment on your cat's display to us right there.
It just sounds like that's a lot of people in the pandemic either out or sort of asked to fill in to add value. So I was just curious what the dynamic is there, if there need to be more permanent utility workers, or that was something related to the pandemic where you needed.
My understanding of the request that came in to have these people go over 1280 was more along the lines that the number of utility workers that they had, a number of them were out for extended periods and or decided that they did not want to be part of the Veterans Home during this period because of the pandemic. So a variety of reasons like that, but it was really just a dramatic drop in the number of people they had available in the system.
Other questions, committee? When I have listened to this, and I will take this up again, but when I listen to this, I see less need to focus on the issue of those who work over the 1280. And since there are so few of them, and most of them seem to be pretty the reasons why they did. I mean, if there were only 31 in 2020, and to focus less on that issue here, but just find out about the other 810 people that are there and how much they work and how they're how they where do they fit in, and do they have benefits, and how do we prorate that? I don't know if the committee, if you have any feelings about that or not. Guess not. Senator Clarkson is shaking her head, and Senator Polina unmuted himself, and Senator Collmore unmuted himself. So, Senator,
I think it's worth it.
Okay, Senator Collmore.
I think you're right.
Senator Polina.
I think Senator Collmore's right.
Well, thank
He's
you.
almost always right. Almost always. So does that make sense to you, Vince, that is where we should focus our attention, given the fact that there were only 31 temps in 2020 that went over, and we have an accounting for them?
Well, we think the department has done a great job at getting a handle on this since VSEA began to beat the drum several years ago. So we give them a lot of credit, but it's not much solace to the 31 people or the ones that otherwise would qualify. Plus, there is part 2 of the bill, which does provide some benefits to them, as I mentioned, you know, some type of sick leave so they don't have to show up for work and get everybody else in the workplace sick when people work in a workplace, and some other limited benefits. You've used the term prorated. We would simply give the temps some coverage so that they would be able to, after 6 months, so that they would be able to have basic minimal, I don't know if human rights is too much of a term, but to put them at least on some par with their colleagues who are classified state employees. And it's, again, it's in part 2, if you will, of H334, which we expect will be embodied in the Senate version of the bill when it's introduced. So we don't represent those individuals who still would not fall under the ambit of the bill, but we think that they should be treated in a way. In a way, HR is making our case. If there's only 3 or 5 or 10 people, then pass the bill, and that takes care of that small group of people. It won't be prohibitively expensive.
I thought that I mean, of those 31 people, 20 were there because of COVID related things. Hopefully we're not going to have COVID related issues forever. And well, it looks like 20, and then 5 in the PSAPs, and 2 who don't want to. And anyway, I think that the most important thing is to look at the other 810 people and figure out where they fit and how they fit into this, and if they're part-time temporary really, or part-time permanent, and how they fit in, and how do they get some prorated benefits, but not focus on the over 1280, because we've heard why they were there. And I mean, maybe we need to focus on those, but anyway, what do you think, committee? Senator Rahm?
I'm sorry, I may have missed this, but is it sort of unspoken that they also get some preference for a permanent job that opens up in this area?
You mean those 31 people or the others?
The others, or everyone who's a temp worker. are they given some special consideration per any union agreement?
That I don't know, and I would guess that of these 31, probably many of them don't want special consideration for him because they're retired. Those 3 that were talked about in the PSAPs and the medical practitioner,
Yeah,
aren't going to apply for a job. They are already retired with their benefits.
But
And so,
it's
but
a
if
good
other
question,
people,
I think.
if
though,
other,
because maybe others.
if out of those 810, those are the people that I'm worried about. I'm not worried about the 31 at
that's
all.
right. That's what I meant, was just
Yeah.
what consideration do all temporary workers get for
Yeah.
permanent placement? That's something I'm not aware of.
Yeah, and we should answer that question.
Okay, so I can give you a partial answer to that question, I think, if you would like to do so now.
Sure.
What classified positions, and Amy, Amy may have a number of how many classified positions we have open right now around the state. There are a good number of them. We may not have the exact number in our fingertips, but there are a good number of them, and many of them are positions that are similar to the positions that the temps are in now. They're always available to be applied for. When a position is opened, however, they are of course all competitive application positions, right? There's not specific preference given to people because of their temporary employment in a position, but it would be, it would appear on their resume, it would appear on their curriculum vitae, right, that they have a temporary position with the state. So while there is no specific preferential treatment given to temps, it's part of their, what they would put on their application. And it would be known to the hiring managers.
And I would assume that is then up to the people who are doing the hiring.
Right.
Okay. Any more questions or concerns? All right, well, we'll get some of this more detailed information about the other people and their benefits, and does that make sense? And we'll take this up again in a couple weeks. Senator Clarkson?
I would just, in case you're not feeling our support behind you, I completely agree with you. I think that's really where we have to focus our attention, is the 810 and what benefits we are afforded to that group of people.
Senator Rahm?
I would also just love to know I can look through the report, maybe I missed it, but the demographic information about temp workers, and if that differs quite a bit from demographic information about other state employees.
Okay, yep, we can look at that. Is the I haven't looked at the workforce report. Is it out, and should I be going through it? I know we used to get that really lovely little book, but I assume it's all online now. Okay, too bad. But
is it done?
Yes.
Do we have that report on our website?
I believe it's on our website, the Department of Human Resources website. I'm assuming we sent that as a report to the legislature.
it would be on the reports and
Right.
in the general reports for the legislature.
Yeah.
Yep. All right. Thank you. Thank you. And I know this was kind of a vague conversation because we don't have a bill or anything yet, but I wanted to just have a little bit of the conversation before we, and wherever the bill is, so that we kind of know what's coming and can get some more specific information before we go there. Does that make sense? Okay. Thank you. Thank you. And thank you for joining us. Thanks, Amy. Tom, Dan, wherever you are, 2 Vinces. So committee, we're not gonna address the privatization issue that we had on the schedule for today because there was mix up, and Deb Demore with BGS is really the person that needs to be in the conversation with us. And she was not available for today when we switched the time. So we'll take that up at another time. I don't want to even get into it until we can have her here, if that makes sense. Okay. So I think that that's probably all we have for today, but can I tell you what we're going to do tomorrow?
You bet.
Okay. So tomorrow we're looking at 3 areas of elections. We're looking at the checklist, and I don't know how much we can do with the checklist. We'll have the secretary, because a lot of it is federally controlled. So we'll look at that. And then we're going to look at ballots. And I don't know if you looked at the list, but we have guaranteed paper ballots. I think that's already in our statutes that we have to have paper ballots, but nicknames, electronic returns, defective ballots, inner envelope, curing, signature verification. And this one came from Deb Bilodeau, address delivery of mailed ballots to nursing homes. And I don't know exactly what she meant, but I wrote her a note and asked her to give me more explanation on that. I assume that it has something to do with sending ballots to nursing homes, and then the activities director or whoever it is at their works with the people and how they control to make sure that the people are actually the ones that are filling. I assume that's what she meant, but I don't know. And then can we use the postmark receipt as the deadline? And then town clerks. Allow municipalities to mail them out, multiple return options, drop boxes, flexibility for types of elections, consistent polling hours across the state, early processing, write-ins declared, voter ID required, multi-party observers authorized, and same-day registration, get provisional ballots. So that's what we're doing tomorrow. And I'm going to try and make sure that people stay on those topics instead of wandering into the other ones on our elections list. And just for your information, I grabbed my elections folder when I was up at the State House. And here's the list that we had 2 years ago when we did this, the wish list. And I'm going to send you the things that were on that wish list and what we did with them, because we passed a lot of them, like political parties, though, how they had to publish their notice and their reorganization, single petition filed for each office that had to do with the guy that did one petition and then copied them and put different offices on the top. The party decides the winner in the case of a primary. Independent candidates, they're filing. JP's allowed to deliver ballots outside of their own town. We did a lot of things a couple of years ago. So I'm going to send this list to you, so you can see that we haven't been doing nothing.
But
Anthony?
the list that you just went through about tomorrow, do I have that list somewhere?
You should. I sent it in an email.
So it'll be an email from you. I'll find it then.
It said day 1, and then it said next day, and then so it's day 1, and it also, I believe, is on our agenda now. All those things.
I'm sending out an invitation to everyone on the committee and everybody else involved that will have that list, as well as our agenda items and the Zoom information. So you'll have that this afternoon.
Okay.
And will that list also be posted on our website?
It's already posted. It just shows up tomorrow morning.
Oh, okay, great. Do we only post those on the day of the?
The system is set up so things that are posted for that day, for everything goes live that day. So if I were to put something up there for Thursday, it wouldn't show up until Thursday morning.
Even though but the agendas show up, right?
The agendas show up the Friday morning prior to the next week.
So if we listed all of those questions on the agenda, can we do that
So you're saying that we should put all of those items
on the agenda?
Oh, we could do that. We could try, sure.
Yeah, because otherwise, people out there, except the kind of usual suspects, won't have any idea what it is we're talking about. And they won't know if they should come and testify or not. I mean, Brian's town clerk had some issues that she wanted to talk about. I don't know if they were related to this or not, but she wouldn't know when to come if we didn't list them.
Maybe that's something that you want to take up in your chairs meeting too, about those documents being available only the day of the hearing versus us posting documents throughout the week.
If they're documents that people are submitting as testimony or as backup for their testimony, that's one thing. But the questions that we're asking to be addressed, yeah, okay, we can bring that up.
I see what you're saying.
Keisha?
Madam Chair, I just want to be transparent about a request or kind of a issue that was raised to me. And I was looking at the people that it was sent to, and it looks like local representatives in Thetford and Tunbridge area. And then I think they included me based on the Equity Caucus role, because they included Susanna Davis as well. But they wanted to address the way that their towns might like to deal with someone who's engaged in racist or biased behavior as an elected official. And I just don't know if I should just forward this email to the committee to see if it's something that's been considered before, but I just don't know what else to do with it.
I didn't understand the first part of that. Somebody sent something to the House members and you?
Yes, they sent it to Senator McDonald, they sent it to Susanna Davis, they sent it to myself, and then Representatives Maslin and Briglin. So Allison, I could forward it to you if you'd like. It's from the Stratford Diversity Working Group, and they're asking for legislation to create a uniform process throughout the state to disempower elected town officials who engage in discriminatory behavior.
Yeah, that's Mark McDonald. I mean, that's Orange County.
Right, that's Orange County. Okay, sorry for some reason.
No, that's okay.
McDonald got stuck in my brain.
Well,
yeah.
We could look at that, but I don't think that's an elections issue.
Right, I just wanted to bring it up before I just forwarded it to everybody, wondering if it's something that everyone wants to sort of see as an issue that's been raised.
It's a sort of it's a subsequent issue to elections, isn't it? Because it's a subsequent issue. Once you're elected, how do we?
Yeah, but we can't take on everything in this issue in the elections.
No, I don't want to do that. I'm going to forward this to the rest of the committee.
Yeah.
So you all am seeing what I am seeing, because it just didn't go to anyone on GovOps besides me, but it seems like a government operations issue. So.
Sure.
Yeah, and I don't know. I suspect there are. I mean, that's something that I guess we would talk to VLCT about. Also, is how do we, if people, as individual people, I don't know what the issue was, but if they are, as select boards, are they discriminating with their policies or with their personal comments or with the way they treat people in their I don't know what the issue is. So
yeah,
I think it's all of that.
Right.
My guess.
And I just sent VLCT folks like a racial equity municipal plan planning guide, that seemed very helpful and they were really grateful. So I think they're trying to start to help. They have been trying to help municipalities do that work, but
Yeah. Okay. Anything else? But so I know, Keisha, when we first started talking about this, you commented that there were there are communities that feel more disenfranchised from elections. And if we need to, I don't know how we reach those communities with these list of questions. We clearly didn't do a very good job of reaching the BIPOC community when we had the government accountability things. I mean, I think we did everything we were supposed to do, but nobody came anyway.
Yeah. So, I mean, the two things that I can say I'm hearing, and I can try to not speak for others and see who might be willing to speak on these, are what Susanna Davis pointed out to us about harassment and feelings of lack of safety when trying to run for office or serve in office as a BIPOC Vermonter, and then language access in being able to vote. So, you know, those two things are somewhere in our agenda. Those are the things I have heard, but I will also go back to my sort of larger community of local leaders who identify as BIPOC and ask them if there's something we're missing.
Yeah, because we did say that when we had issues that had a significant racial impact, we'll always hear from all communities. Certainly when we're talking about things that have an impact on a significant impact on older people, AARP is right there.
Yeah.
And so I don't know, I sent that letter that I sent, and I sent it to, I think, 23 people, and you are the only person that I heard back from. So
yeah, and you know, I don't, it's a very challenging and impossible responsibility to try and, you know, feel like I can aggregate some of that feedback, but you know, there are a lot of really busy, stressed out, you know, overtaxed people who still, if I text them, might be able to say something, but then they also, it's makes them nervous to speak publicly in a committee and that kind of thing. So I will constantly try to work on that. And I'll see if there's anyone who wants to testify. You know, what people that come to mind are the few local elected officials who are not leaving or feeling under specific threat right now. That's a very hard, you know, thing for me to be able to say, but that in my mind includes City Councilor Ollie Jang in Burlington, City Councilor Zariah Hightower in Burlington, and Rachel Eden, Select Board Member in Hartford. Those are some of the few local elected officials of color left in the state on local town government boards.
Yeah, and
then there's some former ones too that are very articulate. Jameson would be great.
Yeah, Jameson.
Yeah.
Yeah, I just want to, I mean, we can have this general conversation. I just want to make sure that we don't, like, if we're talking about the town clerk's things, how does anything that we're talking about there have a different impact on different communities that we should be aware of? I mean, having consistent polling hours, does that have a different impact on communities of color or on the elderly or on people in the Northeast Kingdom? I think that that's there. The issues around people being harassed and feeling harassed, I think are really important, and we need to get to them. But that I don't know that having consistent polling hours affects that.
Right. I would say for clerks, when it comes to elections, it's having a handle on the most commonly spoken languages.
Yeah, and we had that. We had that on our list.
Yeah. That's the one that I can think of that I've heard a lot about when
Yeah.
it comes to clerks.
I had an interesting experience today in terms of language. I still haven't gotten set up for my vaccination. I have had more trouble because they keep sending me and they tell me that no such person exists. And then when I try to do it again, they tell me that too many people with that information exist. So anyway, so they went through this whole rigmarole about doing all these things and then said, if you need this information in a different, that should be the very first thing that's asked.
Exactly.
I mean, really?
Yeah. Yeah.
When I call my credit card, the first thing that they say is if you, in Spanish, if you want, it doesn't do any good to say it in English. Anyway.
Yeah.
Right. No, you're right. It's right up front.
It's huge. Yeah.
So, okay.
So, I've been trying to find this Human Resources Annual Report, and it's not listed on our website under reports. I can't find it. So,
which report?
The one we were talking about with HR, that I thought it was the Human Resources Annual Report.
It's the work labor force report, I think is called. What is it?
It wouldn't be on our webpage.
No, it's not on ours. Go to the general.
Oh, it's on HR because I'm looking on the legislative website. I can't find it at all.
It should
So
be
it's
on the legislative.
It's on their website.
No, it should be on the legislative website under reports and I believe it's called the workforce annual workforce report or something. It's every year they do it.
Well, I looked under. Anyway, well, we'll find it. And if anybody finds it before me, send it. I'd love it.
You know, there's hundreds on the.
I know, that's why we're finding it, and it's
okay. All right. Do we have anything more that we want to talk about before we? Okay, so Keisha, I think I am going to send the letter that the group of people that I sent the letter to. I think I'm going to send them something that just says we are scheduling elections issues. These are the issues we're going to be addressing. Let me know if you have anybody that wants to testify.
Yeah, I treat those kinds of lists that I have as here's another topic, you know, does that spark anybody else? So I think that's really, really great, Madam Chair.
Okay. Thank you. And I think there were 23 different people.
That's great.
On that list. Yeah. Okay, Allison.
An update. It was submitted on the 15th of January, and it's the State of Vermont Workforce Report. Thank you. Yes. I finally got it with the right title. I found it. Thanks.
Okay, anything else, committee here? People? Okay. I think we have half an hour before the chair's meeting.
Yep.
So we'll take a break tomorrow in that long session that we're going to have. We'll take at least one, maybe a couple short breaks so we can get up and move.
Good idea.
All right.
All right.
And I see Vince is still with us.
No,
you know, our committee is always his safe haven.
That's right. I feel comfortable in this committee. I wish I was there in person.
I know we do too. I mean, we don't wish you were there in person. We wish we were there in person.
Thank you.
Sure. Okay.